My name is Tanya Willow, and you're watching a Canton Community Television special. I'm here with attorney Roger Levine, who does estate planning for the elderly. And Roger, you've been on many programs before here in Canton.
Yep.
You've been before the veterans, and you've been at the library. But we thought we'd do it a little bit differently today so that we can have an interaction back and forth about
Sounds good.
the topic of elder law. And I don't want to lose anyone on this because as the cameras are getting ready for us, Roger, we talked about how this can be a very difficult process for people. They kind of think they ought to do some estate planning, and they think a lot of things are true that aren't true. So I just wanted to ask people, if they're watching, just give us a half hour, just a half hour, to sort of look at something that, at the analogy I made earlier, was like a colonoscopy. You don't really want it, but you better take care of it, right? Because
Okay. I don't know how to follow that. It reminds me of back in college, like a zillion years ago, I went to see this comedian, Robert Klein. He was just coming out. He was very new. Big auditorium filled with people. And all of a sudden you see this door open way in the back and light, and somebody leaves, and the guy screams up, "I get better, I swear." It's very funny. It's always stuck with me.
So we have our studio audience is enjoying our material here today too, so that'll be fine.
Okay.
All right, so estate planning, Roger. Let's just quickly talk about one of the most important aspects of it, which is nursing home protection. Everyone believes that they're not going to go into a nursing home, so they don't need to do this, or that they're a veteran and they don't need to do this, or they have some other, Medicare is going to step in. So let's just, I know it seems like very surface and superficial, but let's just talk about some of the most common mistakes people believe around estate planning.
All right. Well, I mean, nursing home in particular, I would call elder law. It's more of the elder law piece. And nursing home is stuff that people don't want to think about, but it's real. I mean, statistics say 1 in every 2 women ends up spending time in her life in a nursing home, usually the end. 1 in every 3.5 men. I said always looking for that half a man. So it does happen. And misconceptions, I mean, I'll summarize the good and the bad misconceptions. The good misconceptions, people say, oh, geez, if I go into a nursing home, they're going to take my house or take my money. And that's not the case. The state doesn't take your house or take your money. They just say they're not going to pay for your care unless you financially qualify. And as a spousal couple, you're allowed to have a primary residence and roughly $111,000 of other assets. If you're facing the immediacy of a nursing home situation, there are some things that you can do to have a higher amount of assets, but you wouldn't do that until you're facing the immediacy of it. All right, so nobody comes and takes anything. It's just that you have to meet financial thresholds. As a single individual, unfortunately, it's a lot tougher. As a single individual, you're only allowed to have $2,000 in assets, and that includes the value of any real estate. So you definitely want to do some planning prior to that, because if you transfer assets out of your name, you disqualify yourself for state assistance for 5 years. So any transfers have to be done earlier. When you say about the misconceptions that I'm protected, there's 2 things that come to mind. Actually 3 things: Medicare, veterans, and homestead. Number 1, people think that Medicare will pay for nursing home care, which it doesn't. Medicare is basically the over 65 health care program. Part A, hospitalization; Part B, outpatient care; Part D, drug program, designed for what's called rehabilitative care. If a person is out in the community and functioning at this level, and then they have an illness or an injury so that they're functioning at this level, Medicare is designed to do the things to bring them back up or close to back up to where they were. And since it's rehabilitative care, Medicare will cover that.
Simply said, Roger, what that means is that if you're an elderly person, you fall down, you hurt your hip, and they can rehabilitate you, say, within a month, Medicare is going to pay. But if you're staying in that as a long-term care person, Medicaid would pay, but only if you qualify.
Right. I mean, basically, Medicare is for rehabilitative care. What happens is over time, somebody may just become more ill,
Nursing
older.
home material, in other words. I mean, let's cut to the chase.
You get to the point where a person really can't be rehabilitated. So at that point,
they need constant care.
They're determined by a medical staff to be what's called custodial care. Medicare pays for rehabilitative care. They don't pay for custodial care. So when you become a custodial care patient, either you have to pay privately, and nursing homes are running $10,000, $12,000 a month, You have to have long-term care insurance if your policy pays for some or all of it, or you have to qualify for state assistance, and state assistance is Medicaid. Okay, so that's sort of how it works. Just getting back to coverage, so Medicare may give limited coverage. It may give up to 20 days. It may give for part of the first 100 days, but generally it doesn't last longer than that in a nursing home setting. In terms of people being veterans, the VA doesn't pay for nursing home care. They have some limited space at some of the institutions, the VA hospitals, for nursing home care. For somebody to qualify for that, they have to have 100% VA disability, number one. And number two, even if they have 100% VA disability, they still may not qualify. All right, so veteran gives some protection, but not a whole lot for the nursing home piece.
Just as a side note, I asked this of Tony Andriotti, who had called him once, because I have a friend whose father owns a home alone, situation they're talking about, and I said, oh, have you done any estate planning? And her father, and just to emphasize this, it's not just people who don't have any familiarity with these things. Say if you're a carpenter or a plumber and you don't really get involved with legalities, this man is an accountant. I mean, a lot of people make this mistake.
Yeah.
He told his daughter, I don't have to worry about it, I'm a veteran.
Yeah.
And I called Tony, and Tony said, even if you do qualify, there are maybe 100 beds,
Yeah,
and they're
yeah.
always
Well,
full.
I guess
it's
that's my point.
Very difficult.
Yeah, it's very limited on the VA. You have to be 100% disabled, and as you said, even if you are, there's no guarantee. The third false premise on things being protected is people say, I've got the Homestead Act, so my house is protected in case I have to go into a nursing home. Well, I mean, the Homestead Act is a very nice thing for $10. It's now $36, still a good value. For protecting against suits against the house, somebody falls on your lawn or something like that. But it is of no value for Medicaid or nursing home protection because it doesn't protect against any federal, state, or county liens, which is the Medicaid thing. And trust me, something that you're going to get at the Registry of Deeds for $36 is not going to protect you against tens or hundreds of thousands of dollars of potential nursing home bills. So it's important for people to know that.
So let's simplify it a little bit, because some of this sounds from a layman's perspective, and certainly mine, because I've gone through it to some extent, Roger. So I understand it a little bit, but it's still difficult.
Okay.
If you are an aging couple, let's just say you're aging, you're in good health, you and your husband, but you want to make some arrangements because you're hoping to bestow upon your children some sort of inheritance without it going to the nursing home, if one of both of you ever had to go. So what would be a prudent action for this couple, say between 65 and 70, if they're getting older? What would be the prudent thing for them to do?
Well, I mean, for nursing home planning, I mean, there's really two things that I do. Number one is what I call core estate planning. And those are the legal documents that pre-speak any situation that comes up if you either pass away or you become legally disabled for health or financial purposes. All right. There's generally 5 of those documents. I'll just run through those briefly. Will basically says, when I die, this is how I want my stuff to go. This is how I want to get it. This is how I don't want to get it. A lot of times a will is coupled with a trust if there are estate tax issues. A durable power of attorney basically pre-appoints somebody to make financial decisions if you can't make them for yourself. Without a valid durable power of attorney, if you're legally incapacitated, somebody would have to go get a guardianship at the probate court, which guardianships used to be an ordeal, but since they implemented something called the UPC, the Uniform Probate Code, in July of 2009, it's just a nightmare. And I've got the Register of Probate of a particular county begging me to tell people to get these documents because the guardianships are a nightmare. I'll get to the nursing home piece in a second.
Sure.
3 medically based documents, healthcare proxy, valid appointment of a healthcare agent to make healthcare decisions if you can't make them yourself. Once again, without a valid healthcare proxy, somebody would have to get a guardianship if you became legally incapacitated. In Massachusetts, just because you have a healthcare proxy, the medical institution doesn't have to act in any particular fashion. The companion document is called a living will. And what a living will is basically a statement from you yourself that if you're vegetative, comatose, no chance of recovery, that you wouldn't want to be kept alive in those circumstances. That lady down in Florida, Terry Schiavo, what the story was there is she had a health care proxy naming the husband, but she had no living will. So the medical institution said, fine, we see that you're the agent, but where does it say this is what she wants to do? And that's why that was such an ordeal, and that's why those two go together. As if that wasn't enough, the federal government passed something in 2003 called HIPAA, Health Insurance Portability and Privacy Act. which has to do with the privacy of medical records, mostly from the rise of the internet. And so now medical institutions are hesitant to give records to healthcare agents because they're afraid they're going to violate these HIPAA provisions. So now we do a HIPAA release that basically says, hey, if my agent needs access to my records, I'm authorizing him or her to have access to those records. I'm aware of HIPAA. Between those 5 documents, there's virtually no situation that can come up that somebody hasn't pre-spoken for if they pass away or they become legally disabled, and that's the purpose for it. Now, in terms of the nursing home in particular, real estate is usually, a house is usually the biggest asset in most people's estates. And there are a couple of ways to protect real estate. You hear about people putting their kids' names on, and if 5 years passes, the house is protected, which is true. That's something we never do, I never do, because if the kid is the current owner and the kid has a problem, you could lose the house.
In other words, just so it's clear, if the kid is in financial trouble, the bank would have claim because
Well,
that's
if the
legal
kid has a
property?
current interest, if they're a current owner with you, either by themselves or with you on the deed. People talk about trusts. I mean, there are 2 types of trusts, basically. There's a living revocable trust, which is helpful for estate taxes, which maybe we'll talk about a little bit later, which is also helpful for what's called probate, probate being anything somebody dies within their name alone. If an asset's in a trust, it's not in that person's name alone, it's in the trust. All right? A living trust is of no benefit for Medicaid or nursing home purposes. All right?
It used to be. Is that right? Like 100 years?
Not really.
No, not really.
It
Okay.
hasn't been since 1986.
Okay.
Okay. An irrevocable trust, which is written the right way, is of benefit for Medicaid or nursing home purposes. So you can put real estate into an irrevocable trust, or you can put assets, for that matter, into an irrevocable trust. By doing that, you're picking up what's called a 5-year disqualification period. Because you're trying to make assets unreachable for the state in case you have to go to a nursing home, the state says, hey, fine, if you do that, we're just going to say we're not going to pay for your care for 5 years. So you pretty much have to make sure that you're going to stay out of the nursing home.
That's because that's what they call planning, though, Roger.
For
This
5
is why
years.
you make these decisions early.
Yeah.
Because when things start going south, it's too late. You
Yeah.
really can lose a lot of money. You have to. That's why I ask people not to turn or leave us quite yet, even though it's sort of a difficult process. It's something you do while you're still healthy, while you can think it through,
Yeah.
while things are clear for you. And because as we age, and this is terrible to say, Roger, but it's the truth, a lot can happen in 5 years. You can be
Yeah.
perfectly healthy at 75 years old, and at 80, everything can go wrong. So a lot of things can happen to us
Yeah,
in
no,
five short
definitely,
years.
definitely want to pre-plan. One other thing I wanted to mention on real estate in particular, there is another method for the protection of the real estate, which is called a life estate, which basically divides the ownership of the real estate between a current owner, who is the parent or parents, and a future owner, who is generally the kids. All right, that works for a couple of reasons. Number one, it's only the adult child's future asset. So if that child has a problem, generally it's not going to affect the parents who are living in the house.
So that would include, say, if he gets into financial trouble, a divorce.
Right,
So
right.
if this is why it's so emotional and why people don't make these decisions. Say if a parent's concerned that their marriage may not be very good between their child and their
Yeah,
spouse.
that happens a lot.
And they worry, oh, but she's going to get half the house. Does that protect something like that kind of setup?
Well, number one, that would only come into play if both parents were deceased and the house actually went down to the kid.
Right.
And if both parents were deceased and the house went down to the kid,
Then, of course, it would be his
then-
property,
then
so it
it's
would
a
become
joint current asset.
Absolutely,
But
yep.
while either parent is alive, that's certainly not an issue.
Oh, good, okay.
Life estate does also pick up a 5-year disqualification period, but unlike an irrevocable trust, if you need to undo a life estate, you can always do it if you have the okay of the future owners, the kids, and you haven't lost anything, you just haven't gained what you would have had you made the 5 years. Now, a lot of times people say, well, there's still 2 of us around, why do I need to do this? Because you just said, if we go into a nursing home, the spouse who's not going to the nursing home can put the house in that spouse's name, and that's true. All right. The reason I generally advise it when both people are around is if one person dies and then you have a second person alone, that person can only have $2,000, including the value of the real estate.